Mr. Joshua Roch Thomas.
Sir, I support the motions. As regards the first motion, the conclusions of the COP and the recommendations flowing from these conclusions are obvious, as Ms. Khan had admitted to making the untruth. I will elaborate on my support of the second motion, that is, the motion to refer the conduct of Mr. Singh and Mr. Faisal to the public prosecutor. The facts underlying the second motion arose in the course of the COP's inquiry into the untruth. In order for the COP to have come to its conclusions, it must have inadvertently formed its mind on the testimony given by the persons who had appeared before it. As regards Mr. Singh's testimony, the COP has said that it has disbelieved several parts of it, thus giving rise to the possibility that a serious criminal offence of perjury had been committed. As regards Mr. Faisal's testimony, he had declined to answer several questions that the COP had posed to him, which may amount to contempt of Parliament. As set out by the COP, and as mentioned by the Honourable Leader earlier, by the Honourable Leader of the House earlier, Parliament is perfectly equipped and empowered by law to deal with these two matters itself. However, the conclusions and recommendations of a fresh set of COP procedures considering these two matters are highly unlikely to depart from the conclusions already reached in the present proceedings. Furthermore, the potential punishment that may flow from a finding of guilt may have political consequences, in particular affecting the makeup of Parliament, and would inevitably suffer from the mire of being politically motivated. This was also mentioned by the Prime Minister. The gravity of the offences, if made out, would then be lost in such circumstance. In this regard, my view is that it is the correct thing to do, as recommended by the COP, to refer these two matters to the public prosecutor, and if the public prosecutor deems necessary for these matters to go to the court, then for them to go to the court. In fact, sir, I would be extremely uncomfortable if the COP's recommendations were the opposite. That is, for Parliament itself to take action against Mr. Singh and Mr. Faisal based on the facts that arose from the COP's inquiry. In fact, referring the matter to the public prosecutor affords Mr. Singh and Mr. Faisal what may be seen as a second, even third, bite of the cherry, because both the public prosecutor and the courts, if it proceeds to the courts, would consider all the facts anew. If the matter goes to court, Mr. Singh and Mr. Faisal would also be able to avail themselves of the adversarial process in criminal proceedings with all the protections of the Criminal Procedure Code and the application of the higher evidentiary threshold of beyond reasonable doubt for criminal matters. In this regard, I am glad that Mr. Singh has said that he intends to cooperate fully with the public prosecutor, and the points that he and Mr. Faisal, in fact that Ms. Lim made earlier as well, are relevant and can be raised in these proceedings. And this should be a position, sir, that sits well with all parties in this House. Both the government and the opposition have expressed in this House and recognized that the courts should be the impartial arbiters of truth in matters where there may be political consequences or overtones. An example is the debate on POFMA. And in fact, this was precisely one of the positions taken by the Workers' Party as regards FICA last year. The courts are also alive to this role as an independent arbiter in matters that may have a political hue. In a decision in 2020, in which the Court of Appeal considered a matter where the convicted party sought to vary his sentence from a fine of 5,000 to a jail term, so that he would not be disqualified from running in the next elections, the Court of Appeal held, and I quote, "It would bring the judiciary and the administration of justice into disrepute if we were to impose sentences with an eye towards the political process. After all, a court that chooses to impose an inappropriate sentence in order to avoid disqualifying a candidate from standing for election as a member of parliament could just as easily do the same thing to achieve the opposite end. In truth, both outcomes are equally abhorrent and impermissible." And the Court of Appeal added that the only guide for a sentencing court is that it must strive to impose a condign sentence. Condign, of course, meaning appropriate. So I have seen some online chatter that it is a foregone conclusion that Mr. Singh and Mr. Faisal will be convicted and lose their seats. I do not think, sir, that it is a foregone conclusion. There have been instances in which the courts have decided against the government, even in favor or in favor of an opposition political party. Members may recall that in an October 2021 decision, the Court of Appeal allowed an appeal in part by the Singapore Democratic Party, challenging a correction direction by the Ministry of Manpower. In its grounds of decision, the Court of Appeal set out its reasons in extent as to why it allowed the appeal. We can expect that the court will undertake a similarly rigorous examination of the facts and the law in these matters as it does on all matters. And I'm heartened that Mr. Singh had also said earlier that he expected that he would get a fair hearing if it went to that. In this regard, I trust that all parties will allow the legal process to run its course, from the public prosecutor's consideration of whether an offence is disclosed, to, if it turns out as such, the deliberation and ultimate decision by the court. Parties, whether represented in this House or otherwise, should not cast aspersions on the office of the public prosecutor and on the courts, especially if the ultimate outcome is not one they expected or had hoped for. While this matter involves members of political parties, sir, I do not see the recommendations as political machinations. As is evident, the COP or the government could not possibly have been aware of the facts underlying the second motion until they were disclosed in the COP proceedings. I see these motions and any court proceedings that may follow as an exercise to protect the public interests and the integrity and standing of this House, and as a reminder that Parliament and parliamentarians must deal in the currency of truth, and that a failure to do so must have consequences. But equally, where there is no wrongdoing, an accused person must have a fair chance to vindicate himself. And not only must it be a fair chance, but it must also be seen to be a fair chance. Politics is politics, sir. But the facts are the facts, and the law is the law. In the circumstances, my view is that the best forum to determine the facts in these matters and to apply it to the law is the courts. Thank you, Mr. Speaker, sir.